Well, hello everyone, and welcome to One Civil Law, where as always we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is May the 23rd of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. Our story today deals with the FBI violating your rights only about 280,000 times in 2021 in a single year. The FBI violated your rights 300,000 times in 2021, according to a recent unreleased, according to a recent unclassified decision by the FISA court. So the FISA court is the Foreign Surveillance Intelligence Court. It is secret, and it does its proceedings in secret. So it doesn't normally release opinions publicly. Normally, all they do, though, is grant search warrants. So they're kind of secret in the same way a federal magistrate would be secret, because search warrants are typically secret. But they're for the foreign intelligence stuff. And they get approached by the FBI and the other intelligence partners all the time for the warrants. And they get a lot of warrants at an almost 100% grant rate, by the way. It is a very trivial rounding error away from 100%. So the FISA court is more than happy to grant your warrant. But it appears the FBI might have done an oopsies only about 300,000 times. So no big deal. Let's learn more. The FBI misused the surveillance powers granted to them, 278,000 times between 2020 and 2021. So in a single year. They did it in respect to warrantless searches on George Floyd, the Jan 6 rioters, and donors to a congressional campaign. Although warrantless search isn't exactly correct here. It is a warranted search because it's been granted by a court. But, On Friday, the FISA court, which normally doesn't release public opinion, so when they do, it's because something has gone catastrophically wrong typically, released a heavily redacted April 2022 opinion that details the hundreds of thousands of violations of the Foreign Intelligence Surveillance Act, which allows for this snooping by the FBI. So the FISA court had an opinion where they reviewed this in detail, and they decided to share it all with us. And we can go read it together in its redacted form. And we might do that at some point because that sounds like fun. But the takeaway line is, the 300,000 times they violated your rights. That the FISA court will admit to. So how many times they really violated your rights, somewhat still debatable. Is it really only 300,000? Or is that just the most egregious cases where they could all agree that it was done wrong? How many cases are more borderline, a little bit sketchy? How many more? Probably some more. The feds were found to abuse the law in a persistent and widespread manner. Wow. You gave the FBI this unchecked power, and the FBI used the unchecked power. Who could have ever seen that coming? They apparently repeatedly failed to get the adequate justification needed to go through U.S. citizens' communications using the law aimed at foreigners. So yes, there is a law that allows the FBI and everyone else to basically look at the communications of foreign nationals, which, is totally not a problem, by the way, legally, because the Fourth Amendment, of course, doesn't protect those people. If you are a foreign national, if you're in a foreign country, obviously, we can just look at your records anytime we want. That would be fine. But when it comes to looking at U.S. citizens' communications, obviously it's a little bit more concerning. And how connected do you really have to be to the foreigner? And the answer is, well, like 3 steps removed, which basically is everyone in the United States. You are absolutely positively connected to someone doing something illegal by 3 steps of separation. You obviously don't know who those people are. You would have no reason to know that. But you definitely know a guy who knows a guy who is doing something illegal in this world. Because, well, when you just start thinking about how many people that is, once you go 3 levels removed, Of course you are. So if we can sweep in, everyone because of the 3 steps removed, well, that might be a problem. The relevant law is supposed to permit the federal government to spy on communications belonging to the foreign nationals outside the United States, which, that would be fine. No Fourth Amendment problems there. That would be fine. You can do that. Those communications can, of course, sweep up phone calls, texts, and emails with US persons, which is where we get a little bit more concerned when it comes to the Constitution. The FBI, CIA, NSA, and everyone else on the face of this earth, all 14 intelligence agencies that we have in this great country of ours. I can't even keep them straight how many we have, but we've got a lot of them. They can all search these communications without a warrant because, again, to the extent that they're foreign nationals in another country, the Fourth Amendment is a non-issue. So, that would be fine, but, well, how about the US citizens, though? According to, the intelligence community, this information is not actually stored, despite it being in a database. We capture the communications, we have acquired them, but we haven't technically stored them because of how we like to play these word games. It's only actually considered as stored if it's used by analysis. So if we merely acquire the information and hold on to it, but we don't look at it, we haven't stored it. That's what we're going with. And while foreign communications, of course, are fair games, the feds can search 3 levels down. Who the suspect talked to and who they talked to. The 3 levels down. So again, do you know a guy who knows a guy who is breaking the law? Yes, I guarantee you do. Do you know a guy who knows a guy who is breaking international law? Of course you do. Because the whole 3 steps removed, if you know 100 people and each of those 100 people know 100 people who know 100 people, well, yeah, that covers a lot of ground. Although the law is not supposed to be used to surveil American citizens, the government has used this data to do exactly that. Because of course they have. These communications can then be used to prosecute people for crimes, and they have been, that we obtained without the warrant because we were looking at foreign communications. But what's this, an American citizen? Well, we got their data too. No Fourth Amendment problems to be seen here. This power is set to expire at the end of the year unless Congress renews it, which of course they absolutely 100% will. With this looming deadline, the now unclassified court document adds fuel to the arguments that the government may abuse these powers. Wow, the government has been given this power to look at the foreign nationals and their friends and their friends and their friends. And amazingly, no one could have possibly seen this coming. You give the FBI and the other 13 intelligence agencies this wonderful magical tool. If they only press this button, they get to look at the records without the pesky search warrant. How often do you think they push the button? Fairly frequently. Who could have possibly seen that coming? Only literally everybody. But here we are. These abuses have been going on for years, and despite changes to the FBI practices, they continue. Yeah, the FBI has reformed itself as it has several times in the past. When it gets caught up in these sorts of scandals, which happens from time to time, they do the reforms. But amazingly, the reforms seem to not prevent them from abusing it. It's like we fixed the problem, but they always find new ways to circumvent the problem. Because you gave them this wonderful authority. It's like we promised, we have pinky promise, crossed our heart that we will never abuse these problems ever again. The FISA court opinion details the FBI queries run on thousands of individuals, which includes 133 people arrested at the George Floyd protests and 19,000 donors to a congressional campaign. Because they know a guy who knows a guy who knows a guy. Because of course they do. In the latter, the analysis who ran the query advised the campaign that was a target of a foreign influence. but determined that only 8 identifiers used in the query had sufficient ties to foreign activities. So, how connected do you need to be in this daisy chain? Like, how much do you need to know a guy who knows a guy who knows a guy? And as it determines, apparently we're willing to even bend that standard too. Maybe you once talked to someone at a bus stop. That's close enough to us. You sat down to someone on the bus stop and had a talk about the weather. You're a contact now. Uh-huh. Sure. For Black Lives Matter protests, the division determined that the FBI queries were not reasonably likely to retrieve foreign intelligence communications. Wow, we used the magic button that solved all of our problems, and we abused the magic button that solved all of our problems. The Fourth Amendment sure is inconvenient. Let's push the magic button again and again and again. Additional significant violations of querying standards occurred in search related to January 6th, domestic drug and gang investigations, and domestic terrorism probes. It has been said that 23,000 queries were run on people suspected of storming the Capitol. So yeah, maybe we have acquired the records, but we haven't stored them. Even though we've acquired them and we're holding them, and they're in our database, but they're not stored. That's critical. You have to understand that they're not stored. But then when we searched them, and it just so happened that a guy who knew a guy who knew a guy who had been involved in January 6th. What are the odds? Basically 100%. Yeah. While the FBI said it has implemented several changes to prevent the abuse, including better query training and stricter approval requirements for sensitive searches, like those involving American elected officials and journalists. Hey, the FBI would really like to spy on the journalists, because the journalists sometimes talk to people, like off the record, and we'd like to talk to them, and we'd also like to spy on Congress, because, that doesn't raise any implications at all with the executive branch spying on the legislative branch. That doesn't raise any serious constitutional separation of power crisis questions. Oh, no. But we're doing it anyway. But, the opponents have suggested that maybe the FBI's pinky promise really shouldn't be relied on. And maybe Congress should look at this and, maybe evaluate whether this is a good idea in the first instance. Even with a long history of FBI abuse, which, basically, yeah, the FBI has been abusing its power basically since it's been constructed, which, to be fair to the FBI, is not just a special FBI problem. The government in general likes to push its powers to the limit. One of the reasons I hate Chevron so very, very, very much, because they are like, if I push this button, I get more power, and it will allow me to do good things for the greater good. And like many roads to hell, it probably was started with the best intentions. It probably was. Someone pushed the button for what were very, very good reasons. Undoubtedly, it's true. And then the reasons became a little less good, and a little less good, and a little less good. And we slide down the slope until suddenly we're a tyrant. So just this one time, we promise we can stop anytime we want. Yeah, maybe you have a problem. Maybe it's time to go to whatever the AA equivalent would be. Intelligence Abusers Anonymous. Hi, I'm the FBI. Hi, FBI. Today, I only abused 30,000 people's rights. Oh, what a triumph. You're making such progress. The systematic misuse of the warrantless surveillance tool has made the relevant law as toxic as other abuses of the Hoover administration, which, I think is fair. Although, of course, modern technology makes it more in sort of its quantity. So we're able to do a lot more with the abuses. We're able to affect a lot more people than the abuses, but in sort of its overall arcing principle, yeah, That sounds about right. Absent a full overhaul of the relevant law, Congress should not allow this to be extended, but they totally will. So, good things to look forward to. Thus, that brings us to the end of the discussion about how the FBI only violated your rights 300,000 times in the 2020 to 2021 period in 1 year. 300,000 times. It's almost 1,000 times a day. That's a lot, Hey, what's a couple hundred violations every single day? What is 100 violations every single business hour, every single day, 365 days a year? What is 100 violations every single hour for 8 hours every single day look like? About like this. And the FBI has been doing this for only the best of reasons, don't you know? And has been doing it 300,000 times and spying on politicians, journalists, protesters, all kinds of people from records that they had, but didn't store. Really important that you understand that, not stored. And maybe we need to take a second look at that law and think about how we define it and maybe try to restrict the intelligence apparatuses. But that, for the moment, brings us to the end of discussion of this story. All right, good morning, everyone. How are you doing today? It is Uncivil Law today, and I am happy to be here to you today. I am in a great mood today. I love you all. Today is a great day. The FBI may have looked into uncivil law. Who knows? Again, do you know a guy who knows a guy who knows a guy? The answer is yes. Yes, you do. Absolutely do. I know 100 people who know 100 people who know 100 people. Yeah, I absolutely know a guy who knows a guy who knows a guy. Has the FBI, as a result of my coverage of January 6th or something, perhaps done a little inquiry? Are some of the people watching this program part of the FBI? Have you been spying on uncivil law? Please don't spy on uncivil law. But you're welcome to like, comment, and subscribe. So if the FBI would like to hit that subscribe button, that would be perfectly fine. You're more than welcome to watch my programs in their entirety. And I encourage you and all your FBI friends and the entire intelligence apparatus to watch my programs. Please, CIA, NSA, FBI, Geospatial, and everyone else, please hit that subscribe button because you'll get all the best intelligence, I swear. I know things. I know so many things that you want to know about. Subscribe and you'll hear the hidden messages in the words. Yeah. Okay, great. I had a great improv class last night. Level 3 starting. Kick ass. And I think I have found I think my ability to generate thumbnails and stuff is getting even better. I think I've found a new way of doing things in a way that should hopefully produce even better results. So I'm very excited about these possibilities. And I also upped my subscription for the AI generated shorts because I was burning through my hours. So good. All right, let's see who else we got. All right, this is good. Let's do this one. Push the button. Yeah. CVS is being sued for improper hiring practices in violation of a state law that forbids an employer from using a lie detector as part of the process of screening applicants. So this is a state law specific thing. Some states have different rules when it comes to hiring practices, and the state of Massachusetts says you can't use a lie detector as part of the hiring process. Okay, well, CVS didn't use a lie detector exactly, but they did use AI to try to assess a person's truthfulness. So is that the same thing? Can you use the AI to detect truthfulness? Also, is the AI really good at this? Is also an unspoken of question, but let's learn a little bit more about this lawsuit and what CVS is being accused of. A class action lawsuit was filed in the great state of Massachusetts against CVS by a resident of that state who failed to get a job at the Rhode Island based drugstore chain after completing an AI assisted video interview conducted using a platform called HireVue. So CVS wants to hire people in many states. Fine. They use some sort of video interview AI thing, and the AI monitors the video to determine whether or not a person's being truthful. So is that the same thing as a lie detector? Okay. It is illegal as a matter of state-specific law in Massachusetts to use a lie detector to screen an applicant, but what if a company uses artificial intelligence to help assess a candidate's honesty? That's a good question, because if a person did this, that wouldn't really be a lie detector, right? If CVS hired, some people who were particularly good at screening people for truthfulness, which incidentally, people suck at universally. This has been documented over and over and over again. And even people who are supposedly good at this as a matter of profession basically suck. So, think FBI, think judges, think law enforcement in general. When they do these kinds of tests, and is this person telling the truth or are they lying? The professionals only do about 5% better than the average man off the street. And the average man off the street gets it right about 55% of the time. So average guy determines truthfulness correctly about 55% of the time. Trained professional, 60%, low 60s. Okay? We are not much better than a coin flip at this. We are not good at this because amazingly, human beings are wired to detect this deception and also wired to help undetect deception because we are pretty good at lying to people because we're really good at it. We've been trained a long time. So our ability to detect it and our ability to generate it are about on par. And so if we tried to hire a guy to do this, well, that probably wouldn't go very well, but we could at least in principle, right? Well, what if we hire an AI? And the AI is better than, every human being, which wouldn't be that hard, one would think, because human beings suck. Is that the same thing as a lie detector? So if the excuse me. So if the AI is doing this, is the same thing as a polygraph with perspiration and heart rates. Is it unfair for employers to use a machine to help evaluate integrity? Or is it more fair than relying on subjective judgments of humans, which, as I've been mentioning, is really, really horrible? Human beings suck at this. These are some of the questions that surround this class action lawsuit filed last month in state court. Who failed to get a job at the drugstore after completing the AI interview? He is filing, of course, on his own behalf and as a member of a class of others who might also have not been hired for the same reason. The use of artificial intelligence is, of course, becoming more dominant in every aspect of people's businesses, including, of course, in hiring and firing. The AI will help solve our problems. So this, of course, fuels questions about how this interacts in the workplace and the harm. Calls for more rigorous testing and regulations, of course, from the government have been trying to be spawned by this. Some states, of course, are reacting to this. States can sometimes react faster to this than the federal government can. So some states have already gone on board. And also the federal government, to some extent, looks at what states are doing as a matter of inspiration and as a matter of what things work, right? The laboratories of experimentation among the states. So sometimes the federal government kind of looks and sees what happens in various states. And then, if things work well, they'll adopt it or use it as inspiration for their own ideas. So it's not surprising that some states are getting out ahead of this, and this will be refined as a matter of state law before it probably gets refined eventually as a matter of federal law. But by the time that happens, it'll probably be too late because the AI will advance so far. But let's pretend that we'll be able to get to this in time. The White House and other federal agencies have announced their commitment to looking at artificial intelligence. The EEOC is urging employers to analyze technology to make sure that the decisions are not discriminatory, warning that those responsible for it would be, of course, responsible for it. So if you use a tool, you're responsible for your use of the tool, which kind of makes sense. It's like, oh, the tool did it. No, not yet, at least, not legally. Maybe someday with the AI advancing. But for the moment, the employer is still responsible for their own decisions. So the AI hasn't advanced that far yet, but maybe later. It is unclear, of course, how laws that have been on the books for decades might apply to this novel situation because the laws were not designed for this. And this is a bit of a shift in technology in a way that, will break some laws in sort of not being able to be applied readily. So our ability to read the law onto the AI in a lot of situations maybe not so clear because this is such a new kind of technology. How much artificial intelligence can help or hinder in these processes, of course, remains to be seen. So it would be a bit weird to draw the conclusion that AI cannot be used, for example, as part of the hiring process, but how much? How much is it allowed to do so? How much does a human being have to be in the loop? And so forth and so on. Like a number of other organizations, including T-Mobile, Delta, and the Boston Red Sox, CVS has used these video interviewing platforms to help screen job seekers. So this apparently is not, an unknown thing. This appears to be in many, many unrelated industries. So the video interviewing platform AI apparently used as part of this process. So, okay. In about a third of the interviews, HireVue uses AI technology to analyze integrity and honor to help companies scale out lie detection and screen out embellishers. So, yeah, apparently a lot of companies are using this to help thwart people who are perhaps fronting more than they are really, presenting good stuff. And how good is the technology? One wonders on this. That's something I would want to know a lot. At the time this individual applied for the job at CVS, HireVue's AI enhanced interviews analyze facial expression, eye contact, tone of voice, and inflection. So they are the body language expert people brought to AI. The body language experts brought to AI. Oh, your eye moved this way. Your eye moved that way. You had this tone. Your eyes moved. That shows deception. Uh-huh. I have to admit, which will come as a surprise to no one who follows my channel with great attention, that I am very skeptical of this body language stuff. I have a lot of skepticism that you can read anything from a lot of this stuff and that things mean things. I have a lot of skepticism behind the people who claim that they can do this as people, and I have skepticism on the AI. So I have my doubts personally, but that's perhaps a personal bias. Federal law has prohibited most private employers from using lie detectors to select employees since 1988, although, of course, for certain sensitive jobs and other jobs specified by law is permitted. So it's not a universal thing, but for most jobs, it is prohibited. Massachusetts law goes even further, forbidding employers from using a polygraph or any other device, mechanism, or instrument to assist in or enable the detection of deception, which, to be fair, this does sound like that. So, under Massachusetts specific law, the way it's defined, this does sound suspiciously like that. So, this might be a violation of Massachusetts specific law and perhaps other states as well. And whether or not it should be or not is a whole nother set of policy questions. but we're over here to do law. Sounds like a legal problem for the moment. CVS's use of the AI screening technology violates the state law according to the lawsuit, which notes that HireVue, the AI, records candidates responding to a list of questions that could include ones pertaining to honesty, such as, tell me a time that you acted with integrity. All the time, CVS. I'm nothing but a font of integrity. I'm acting with integrity as we speak. And what would you do if you saw someone cheating on a test? Snitches get stitches, yo. In a statement, HireVue's chief data scientist said, our assessments are not and have not been designed to assess truthfulness. Okay. Instead, they say HireVue uses tools based on validating industry organizational psychology to help human managers evaluate whether an applicant's answers are statistically linked to important work-related competencies while mitigating. Have I been muted? God damn it. Fuck. I'll do the line again, no problem. I got it, it's fine. Everything's fine. Everything is awesome. Everything is cool when you move to the beat. Everything is awesome when you're living the dream. All right, I'll just redo the paragraph again. In a statement, HireVue's chief data scientist said, our assessments are not and have never been designed to assess the truthfulness of a candidate response. Oh, you say? What are they designed to do? Instead, they say that HireVue uses tools based on validated industrial organization psychology to help human hiring managers evaluate whether an applicant's answers are statistically linked to important work-related competencies while mitigating human biases. This is a more reliable and scientific way to focus on skills than simply believing what's written in a CV, as they could be inflated by the writer. Yeah, I mean, with all due respect to HireVue over here, that sounds suspiciously like evaluating honesty, but with extra steps and in corporate BS speak. We're not evaluating honesty. Oh, no. We are validated industrial psychology, statistically linked competency. That's totally different than evaluating honesty. I don't believe you. And even if I did believe you, that would still be evaluating honesty, but just with extra steps. I think you might have a legal problem over here in Massachusetts. The AI understands the meaning of candidates' answers, does it? Does it really, though? Okay. According to HireVue's explanation of assessments, and considers the relative weight of words, job seekers who use the word team, for example, boost scores on teamwork. So basically, we're just doing like tagging and metadata. So now it just becomes a question of the right metadata. So we figure out how to fool the AI by just throwing in the right buzzwords. So this is just which buzzwords do the AI like? And if we use the right buzzwords, maybe we can get lessons on the buzzword speak from the team, from the AI people that we just talked about just now, because they seem to be really good at it with the BS wording. And we can get some coaches that will tell us how to use all the right words, team and synergy and, you know, all that bullshit. And if we use enough of the words, the AI loves us. Wow. HireVue was also named in a recent lawsuit filed against a different company But that case was voluntarily dismissed for whatever reason it was voluntarily dismissed. So who can say why? But we're giving it another go with CVS. And for all the non-subjective, unbiased analysis AI is supposed to provide, which, I'm not sure I believe any of those things, because we've seen with AI that it can be programmed with bias in mind. We can see how it reflects the perceptions of its creators and moral perceptions of its creators. So unbiased, I don't know. Also, I'm not sure how good it is at that. But even if it were all those things, it would still only be as fair as the data behind it. In 2018, Amazon scrapped its AI recruiting tool after discovery the system favored men over women. Yeah. Now, one would wonder, just as a matter of pure policy, is it because the men are in fact better than women? Because then that wouldn't be discrimination on the basis of sex, right? To discriminate on the basis of sex, you are discriminating because they're a woman or because they are a man. But if through a purely objective evaluation, assuming such a thing were possible, if it just turns out that men are better than women or women are better than men, as the case may be, that would not be discrimination on the basis of sex. So one would wonder, was it that the tool was just really good at its job, but we didn't like the answer? I wonder too. Despite these problems by various companies, including Amazon, these tools are, of course, popping up in lots of different employment because they promise fast, efficient, unbiased acquisition. It's important that employees who use these services invest in proper compliance and training and transparency. They've also cautioned against using AI too early in the process before a human is determined if a candidate is a good fit, though they think initial screenings are also likely to be automated if they haven't already been. So yeah, AI in resumes, AI in looking at resumes, AI is in job hiring, AI in evaluation, AI all the places. So yes, it is coming to all the places rapidly. All right, that will wrap that story up. I really don't care, Harry. I don't give a fuck. Other people in LawTube are able to come up with their own opinion. I'm giving you mine. Lawyers disagreeing. Wow, film at 11. Thus, that brings us to the end of this story about CVS being sued for the use of AI hiring, because maybe it's the same thing as a lie detector, which, given Massachusetts specific law, maybe it is under the way that it's defined. So, okay. And other companies are using this in various parts of the hiring process. And there you go. So we will see how this all develops as the federal government also looks at this technology for its validity and possible discrimination. And eventually the government will get involved. By then, probably too late because of how fast the AI technology is moving. So that's fun. And that brings us to the end of discussion of this tale. Thank you, Bella Stella, for the gift memberships. It's very kind of you. I appreciate it. And I think there were some gift memberships earlier. Let me scroll up and see if I can find them. Hold on one second, please. I want to say thank you. Was there another gift membership yet or no? Or was this the first one today? Because I didn't want to miss them. Well, thank you for the gift memberships in any case. They're always appreciated. Thank you. There was one earlier, I thought so. I just couldn't find it in the list. Oh, Contrarian gifted 5 memberships. Well, thank you very much for the 5 gift memberships. I appreciate it. Yeah, I just couldn't find the notification, but thank you very much. It's appreciated. Thank you, Contrarian, for the 5 gift memberships. That's kick ass. All right. Let's do another story. We got so many good stories today. This could be a long recording session, maybe. We might be here a while. How are we doing on time? Oof. Oh, hit the button. Thank you. Yeah. I'll keep you entertained until Emily starts. Well, I'd hope you stick with me in any event, but you know. All right, let's get going. Okay. Am I getting a swoop? Rob said he'd make me one. So if he makes me one, then yes. No, I stand by my opinion, Les. I stand by my opinion. I believe in what I said. I'm just not going to continue defending myself because you want me to. You know, so fuck off. In gun control news, the Michigan governor has signed into law a new red flag gun law, as many states have done. But of course, questions linger over how it will be enforced, under what circumstances, and when. So, yeah, this is a problem, right? We want to potentially take people's firearms away, potentially without as much due process as we might, ideally want. And this is a bit of a tension. And also, of course, gets into questions about the Second Amendment. So let's learn a little bit more about what Michigan has done in this state. Michigan has joined Minnesota as the second state in under a week that implements a new red flag law, after Democrats, of course, in both states won control of both chambers and the governor's office. So as the parties have shifted in these states, and as Democrats now have the power in the states, both states have now passed red flag laws, the first states to do so since New Mexico in 2020, but of course, other states have passed them as well. The governor signed the legislation just outside Detroit, flanked by various lawmakers and individuals. Arizona Congresswoman Gabby Giffords was also present during the signing. The new law, also known as an extreme risk protection order, is expected to go into effect next spring because, again, as is very typical, states, when they pass laws, they don't go into effect right away, right? Very common July 1st, very common January 1st. But for whatever reason, for this particular law, apparently something like March. So I don't know why, but that's what we're doing over there. This law would allow family members, police, mental health professionals, roommates, and former dating partners to petition a judge to remove firearms from those they believe to pose an imminent threat, which of course in no way could possibly be abused by some of these people who might have a bit of vendetta against the person and just want to make their life more difficult because they can. But I'm sure that will in no way be a problem. The judge would have 24 hours to decide upon the order after the request is filed, which isn't a lot of time to consider such things. And how would they go about evaluating it? other than, just the naked thing. So why would they say no? Right? So if granted, the judge would have 14 days to set a hearing during which the flag person would have to prove that they're not a risk, which also seems a bit weird that they have to prove they're not a risk as opposed to them proving they are a risk, but okay. The order would last a year. So we would take away your guns and we'll pinky promise to give them back to you after a year, although that will absolutely not happen. So your guns are gone forever. So fun. Michigan became the 21st state to implement a red flag law. Questions remain of whether the state will have better success in enforcing it than other states have had, because other states have run into problems, including legal problems, because of the Second Amendment issues, for many obvious reasons. You want to deprive someone of a constitutional right, on someone's mere say-so, with different or less or sometimes no due process. So that's a bit of a problem. The Associated Press found that in 19 states that currently have the laws, there were 15,000 times that firearms were removed from people, but that's fewer than 10 in 100,000 residents, but still 15,000 times. So 15,000 times firearms have been removed in a way that might not necessarily comport with due process. So yeah, these laws have problems, lawsuits all over the place. Some local sheriffs have told the Associated Press they won't enforce the law if they don't believe it's constitutional. So setting up a potential fight within the executive of a state. So that should be interesting. Over half the state's counties have passed resolutions declaring themselves to be a Second Amendment sanctuary, opposing laws they believe to be infringing on gun rights. So the state is to some degree fighting itself on some of this stuff and raising all kinds of questions of how much does the state really want to do this, right? Because the state has ultimate control over its own state apparatuses. So the state can, if it wants, win this fight. But of course, that raises political problems as opposed to legal problems. So if the state really wants to come on and your laws are dumb, we are God, you will bow to our will, they can do that. But do they have the political will to do that is a whole nother set of problems. So we'll see how that goes. For those in law enforcement who refuse to follow these orders, let me say this loudly and clearly. I'll make certain I find someone who will enforce the law, the Michigan Attorney General said. Which, okay, fine. You might very well be able to do that because, again, it's a matter of state law. So maybe you can find someone to enforce it, but you're still setting up a political fight. So we'll see how that all goes. Nearly half the states have passed legislation relating to gun control this year. But of course, there's a division among states. Democrat-led states have enacted new laws to restrict stuff. Republican states have passed laws not to restrict stuff, including allowing concealed carrying without permits or for trained people to have guns in schools. So two very, very different approaches by the states. Earlier this month, 2 school districts in Michigan banned backpacks as a result of this firearms problem. So I'm not sure if that means all backpacks or you're just allowed clear backpacks or something. Because how you get around without backpacks is a kind of a real issue, to be honest, if you're in high school, and even college and stuff like that. The backpack is key. So I'm not sure how we can ban all backpacks, but we're trying. The ban at the public schools came as a result of a third grader who brought a gun to the school, which is bad, but maybe leading to other problems. The red flag law is the final piece of legislation to be signed into law as part of 11 bill gun safety package advanced in the state. So the state is passing many, many laws for the gun control. This is one of the laws for the gun control. Safe storage and universal background checks, also part of the gun control in this state. So we are not, avoiding the fact that we have all this wonderful power as state because we have a unified Democratic-led state level government, and we are just passing all the gun control because we can. You weren't allowed backpacks and had to carry your books everywhere? God damn. Your high school banned backpacks and lockers? Holy shit. How do you even do that practically? Holy shit. How does that even work? God damn. Michigan Democrats, who are in control of all the state government for the first time in 40 years, of course, said the 11 bills they've already passed is yet but the start of their measures, because of course it is. This represents a floor for what we can do, the Michigan Lieutenant Governor said. And it is planning even more gun control, surprising absolutely no one. So the state is looking to, push the Second Amendment to its absolute limit, other states going the opposite direction. All this, of course, leading to many, many legal fights in the future, including eventually at the US Supreme Court for all this stuff, as states go somewhat out of their way in some cases to push the boundaries, just because they can. So, leading to all kinds of legal fun in the future. Ban Lisa Palmer, please. Thank you. Just keep banning the trolls. Thus, that brings us to the end of discussion of the Michigan governor who signed a red flag law. And there are questions over the issue because, there's also fights within the state on these issues, as there expects to be. Because, one political part of the state is fighting other political parts of the state, cities and counties and sheriffs going one way and stuff like that. Is my mod? Do I not have any mods here? Do I have to do it myself? Thus, I've totally lost my train of thought. Thank you. I'll just redo the outro. Thus, that brings us to the end of this story regarding the Michigan governor and the state's Democratic officials, which have signed 11 different gun control levels at Thus, that brings us to the end of the story of the Michigan governor, along with state level Democrats who have together crafted 11 gun control bills, but this is but the start of Michigan's efforts. Other apparatuses of the state, including county level authorities such as sheriffs, have said that they will resist this. And so Michigan is on a bit of a collision course with itself. Of course, Michigan is sovereign, states and localities are not. So ultimately, Michigan can legally do whatever the hell it wants when it comes to counties and sheriffs and cities. It has ultimate unchecked control. But that poses not so much a legal problem, but a political problem, as different parts of the state squabble over these things. Of course, turning our attention to the legal problems, even if Michigan has ultimate power over its own state, it doesn't have ultimate power over federal law, which includes the Second Amendment. So Michigan will have to contend with the legality of its measures as it's a matter of federal law, as other states adopt these and other gun control measures, and seeing how far they can push the envelope. So the Supreme Court, again, looks like we're going to have more and more issues going to the Supreme Court on gun control issues. Michigan teeing up many issues itself, and that for the moment brings us to the end discussion of this case. Push the button. Push the button. Yeah. Sometimes this change isn't very deep, but that's okay. It doesn't have to be. Not for nothing, but of course, Bronca once praised me, at least as an expert. There's a clip of it on my channel. And, I don't believe that Bronca has visited me personally. And I visited him. And as far as I know, we are simpatico. So there's no drama as far as I'm concerned with Bronca. We have our differences. I don't always agree with him, including, incidentally, in his own subject matter expertise, which is also interesting. When you are outside, well, what Bronca is more of an expert in his subject matter than I am, and I acknowledge this. So when I disagree with him and he's more the subject matter expert, it's like, okay, you want to sort of double check yourself because you're like, I'm disagreeing with the subject matter expert. But that being the case, we get along fine. I also don't know 100% why people try to spurn drama among the LawTube creators. I don't really know why they keep trying to do this. I don't really have any beef with anybody. I like everybody. And I like being with everybody. And I like talking with everybody. And you know, different people have different styles and we are all very different from each other, but I sort of appreciate everyone for what they bring to the table because they're all smart in their field. And I appreciate them for what they are. And I happily have and would continue to collaborate with them again. I don't collaborate with them very often on my own channel, but that's just a matter of my own style. It has nothing to do with any antagonism towards them. It's just I prefer a little bit more solo for the time. But okay, you know, we're all friends, and there has been drama in the past, including from myself, because we have all made mistakes, or many of us at least have made mistakes along the way. And that's part of the reason we learn from the misfortunes of ourselves and others, right? There are mistakes. Some of these mistakes led to some real hurt feelings and some real harmed relationships. Hopefully someday, somehow, those will be repaired, you know, but we definitely have made mistakes along the way. We learn, we try. We are human beings. It's true. All right, let's see what else we got. We got a lot of stories today. All right, let's cover this lawsuit. All right. Yeah, Bronca isn't your cup of tea. I understand. I understand. I am not saying I am not saying that you are not allowed to have personal preferences in your taste. I am not saying that you're not allowed to like some creators and not like other creators. That would be dumb. There are a number of us, and obviously everyone brings something to the table. And obviously, every single one of you is going to have your own preferences. And I may not be number one for all of you, and that's okay. I appreciate all of you who like me, no matter where you rank me in the grand hierarchy of such things. And if there's a particular creator you don't like, I totally understand and I totally get it. Some of these people will not be to people's taste, and I can totally see why they would not to be to someone's taste. For some of the people, it's not very hard to figure out why they wouldn't be to someone's taste, you know? But, their rough edges is what someone else really appreciates, so it is the thing that they are, I suppose, polarizing for lack of a better description. Some people really like the polarizing stuff, right? So you can play it really safe where you have no rough edges, but maybe that's uninteresting. When you have some rough edges, some people will appreciate those edges because they really like those features, like art in that way, I suppose. So of course you're under no obligation to like everyone. But I just have no beef with anybody, you know, and I appreciate what they're doing. So, you know, all right. In foreign people obtaining property in the United States news, the state of Florida has a law that attempts to block Chinese citizens and other foreigners from buying property in its state. This is something that other states have done, not only in modern times, but also throughout the years. This has been something that various states have done for at least the last 100 years, trying to prevent foreign nationals from buying buying property within their state for a bunch of reasons. Sometimes these reasons are okay, sometimes not. We will look at what Florida is doing and try to assess. Let's get started with this. A group of Chinese citizens who are living and working in Florida sued the state Monday over a new law that would ban Chinese nationals from purchasing properties in large parts of the state. The law would apply to properties within 10 miles of a military installation and other critical infrastructure, and also affect citizens of Cuba, Venezuela, Syria, Iran, Russia, and North Korea. But Chinese citizens and those selling property to them face the harshest penalties. The prohibition also applies to agricultural land. The American Civil Liberties Union says the law will have a chilling effect on sales to Chinese and Asian people, who they say can legally buy property. The lawsuit says it unfairly equates Chinese people with the actions of their government, and there's no evidence of national security. All right, so let's discuss the law very briefly on this issue. The law is a bit complicated, but we can start with the US Supreme Court in 1923, 100 years ago. In 1923, the US Supreme Court heard the case of Terrace versus Thompson, which dealt with an issue in which a state, in this case, it was the state of Washington, passed a law which prohibited foreign nationals from purchasing, using, or leasing land. All right, so they said you can't do this. And again, it was also based on anti-Asian biases. This dealt with Japan, principally at the time, because of course in 1923 our relationship with Japan was a lot different than it is today, as also our perception of Japanese Americans was a lot different than it is today. So in 1923, the state of Washington said the Japanese citizens can't purchase, use, or lease land in our state. The US Supreme Court in 1923 said that this was legal and not a violation of the 14th Amendment. The 14th Amendment guarantees equal protection, but it guarantees equal protection of US citizens and US nationals. It doesn't guarantee equal protection necessarily when it comes to foreign nationals. So as it relates to that, that's fine. Now, where you get into a more tricky aspect is where a US person or a US national is involved in the transaction, or they're the descendant of someone who is a foreign national. So if you have a US citizen or a US national who is sometimes related to, we've had those cases, sometimes invested with, we've had those cases, sometimes a partner with, we've had those cases. If you have that situation, which is impacting US persons, now suddenly you're in a lot more of a legal tricky situation because you can't really do that. So to the extent we're talking about just foreign companies, just foreign nationals, then probably lawful. To the extent we're talking about more complicated relationships, which to be fair, in 2023, there are a lot more complicated relationships than there were in 1923, because in 2023, it's a lot easier for people to communicate all around the world in real time and to have much more complicated relationships because of things like planes and the internet and radio and other communication mediums that exist. So the degree to which foreign nationals are integrated or involved in these more complex relationships is, of course, a lot more complex than it was in 1923. So is it legal? Is it not legal? Well, it's going to depend on the details. And this is an area of law that is not particularly well defined, to my mind. It's not particularly well defined. So we will see how the courts look at this particular iteration of it. But there have been cases on this for at least 100 years on these kinds of issues. So we'll go scour the case law for the last 100 years and try to come up with an answer. But I don't think there are a lot of clean answers. The only cleanest answer we have, if it's strictly foreign, you can ban it. Beyond that, it's a little, but we'll see. The law will codify and expand housing discrimination against people of Asian descent. If they're people of Asian descent as opposed to being Asian in their own right, you have a potential legal problem. It could also cast an undue burden of suspicion on anyone seeking to buy property whose name sounds like it might be affiliated with those countries. So maybe that's the problem. We'll be discriminating based on people's names or ethnicity. as opposed to their citizenship, which maybe that's a problem. So, could be an issue, yes. US-China relationships are, of course, strained at the moment. In a nearly dozen state houses and Congress, this worry about foreign ownership has spiked, including in the great state of Texas, which is also looking at measures along these lines. Not for the first time. Will they be upheld? Who knows? The Republican Governor DeSantis signed the bill into law. The law is set to take effect July 1st because it is very common, of course, for these things to take effect on July 1st or January 1st, depending on state. This would make it a felony for Chinese people to buy property in restricted areas or for any person to knowingly sell to those persons. For other targeted nations, the penalty would be a misdemeanor. So we want to make it a felony with respect to China and only a misdemeanor for other people. Also unclear how we deal with people of mixed nationalities or mixed citizenships in potential relationships. Because, we have people, maybe we have an LLC somewhere that has maybe some Chinese people, maybe some Cuban people, maybe an American in there. How does that work? Good questions. Unclear. The law would apply to military installations as well as infrastructure like airports and seaports, water, wasteway, natural gas, oil processing, power plants, spaceports, and telecommunication. That part's probably legal. I mean, given the precedent from the Supreme Court, it's probably legal to just say statewide, period. So the state obviously doesn't have to go that far if it doesn't want to. But the state has made a choice to ban people within a 10-mile radius of all these places, which is probably legal, as long as we're only applying it to foreign nationals and foreign entities. But, that's a little bit tricky. The ACLU says this law will have a net effect of creating Chinese exclusion zones that could cover large parts of the state. This impacts exactly what laws like the Chinese Exclusion Act of 1882 and California Alien Land Law of 1913 did. Yeah, again, this is not the first time we've done this. It's not the first time the US Supreme Court has had to consider this. So for at least 100 years since the Supreme Court wrote its decision in the case of Terrace versus Thompson, at least 100 years and further back, we've been dealing with this issue. So everything old is new again. Those on the restricted list that already own property must register with the state. I'm not sure to what end, but okay. They also are prohibited from acquiring additional property. The law has provisions to allow the state to seize property from violators. So for a taking as a fine, I don't know, that sounds tricky, right? So if we want to take land from people that already own it, we're thinking now that's some sort of fine, right? And now we're looking at a fine that is too high. So we're looking at an Eighth Amendment problem from people who already own land. We want to take land that they already own. Now we're thinking Eighth Amendment. The number of states restricting foreign ownership of land has risen 50%. Heading into 2023, 14 states have laws restricting ownership. Of course, this has been enacted in Arkansas, Idaho, Montana, Tennessee, Utah, Virginia, and very soon to come to Texas, because Texas is looking at this right now and almost certainly will pass some version of it, I would imagine. Foreign land ownership has become a political flashpoint, according to the National Agricultural Law Center, which I think, yeah, but not for the first time. The recent surge in state laws targeting land ownership by these foreign entities stems from some cases of Chinese-connected companies purchasing land near military bases. So is that nefarious? Is it not nefarious? Should we be concerned about it? I don't know, but that's what they're doing. Earlier this year, the U.S. Air Force said that a group affiliated with China planned a $700 million wet corn milling plant near a base in Grand Forks. And the US government thought that this posed a significant threat to national security. So I'm sure they would be milling the wet corn, but what else are they doing? What is it a front for? What kind of base of operations? So the US government also concerned about these possibilities. After a Chinese army veteran and real estate tycoon bought a wind farm near an Air Force base, the state responded by banning infrastructure deals with individuals tied to governments, including China. That part, a lot less clear legally in sort of that. If you're merely tied to, that's a little bit unclear about that. So, some of this, yeah, it's a legal now. It's a legal mess. Thus, that brings us to the end of the case of Florida being sued to block this law that prohibits Chinese citizens and other foreigners from buying property in the state. Is it legal? Maybe. In 1923, the Supreme Court said yes, if it's just the foreign nationals and just the foreign citizens. But today, with the relationships that we have and all that, it's a lot more complicated. So, this will obviously be fought over. And the case law is, I don't really think, very particularly uniform here. So there's not many bright line rules when it comes to this. So this will have to be sued over, and it will take a lot of effort and time because I think it's a bit legally messy. So we will see how that all progresses. And that, for the moment, brings this end of discussion of this case. Messy, messy, messy. Let's see, an hour 12. We're doing good. Let's see. All right. Press the button. Thank you very much. Yeah. I love you all, chat. I love you all. Thank you all for being here and joining me on these recording sessions. You guys make me happy. I appreciate that you're here. I appreciate every one of you who subscribes. I appreciate every one of you who allows me to talk about a subject that I really, really enjoy. Law. I appreciate every one of you who allows me to think. I appreciate every one of you who helps to build the channel up. I appreciate every one of you who's part of this community. You guys are great. I'm in good spirits today. Been in good spirits for a while now. That's been nice. I haven't had a really dark, depressive episode in a while. So that's nice. So I'm not sure what that's due to, nor do at this point do I particularly care. I'm just going to continue to try to enjoy it for as long as it lasts. And maybe it will last really, really long this time. That would be nice. I still have little twinges of depression, but I haven't really crashed in a while. So that's nice. Thank you, Contrarian, for the 5 gift memberships. I appreciate it. Maybe the medication that the doctor put me on is helping. I mean, that would be the most logical conclusion. So, that's good. All right. Yeah, I'm really looking forward to releasing the stories today because I've come up with a new technique that I think will really help. So we'll see how much difference it makes. So that'll be good. I think it doesn't particularly hurt in a lot of ways, of course, that I left my job. That was a major existential pressure on my depression. And it doesn't feel like a year ago. It really doesn't. But it's been almost a year. I think it's a year in like June. So it's coming up pretty soon. It doesn't feel like a year at all. It really, really doesn't. Uh, but that was a major existential pressure on my depression. And that being removed, and now that it's sort of like becoming more real that I really left, now that that trauma is becoming more and more removed, I think that goes a long way to helping. Yeah. The exercise probably also helps. So they're good things. Yeah, that year went by really, really quickly, didn't it? And we're still here. We're still thriving. There was nothing wrong about my job in sort of an objective sense, right? It just the problem was there was nothing new, there was nothing left for me, right? It wasn't the right job for me anymore. I got to a place where I knew everything there was to know about my job. I've been doing it for 15 years. So I don't want to sound unduly arrogant, but like I don't know how to say it other than by saying I knew everything. I knew everything about the job. I knew everything about the law in that field. I knew everything. I had learned everything. And so like there was nothing new for me. And so it became just very rote and monotonous, and that's a problem for me. You know, that there was nothing new to learn. So, yeah. It's one of the reasons, incidentally, that I don't talk about patent law on my channel because I don't like it anymore. I don't like patent law because, like, well, I already know it all. So, tell me a different story, right? But I wouldn't necessarily discourage someone else from taking the job. It would definitely be the right job for someone else. So, in response to a recent federal law that aims to stop surprise billing at hospitals, there has been an increase of actions dealing with surprise billing at hospitals. So the federal government took note that a lot of people get bills from hospitals they don't necessarily expect. Because when you go to a hospital, you run into the issue of not only does your insurance cover the hospital itself, but also the person at the hospital, which sometimes they don't, right? So who is within your plan might depend on the individual doctor inside the hospital. And of course, depending on the situation, you may not necessarily be in a position to know or even be conscious of who this person is. Because if you're going to a hospital, maybe it's because there's been a catastrophic emergency. And maybe you're not really in a great position at that particular moment to ask questions like, hey, are you within my plan? You know, or even conscious at the time. So we are concerned about this possibility. So the federal government stepped in, but of course, now the lawsuits have come. Let's learn a little bit more. In a year following the implementation of an arbitration process established under the federal law called the No Surprises Act, 330,000 disputes have been submitted for the arbitration. This figure outpaces predictions from the federal government and complicates implementation. So, yeah, the federal government said, all right, we're going to set up a process so people don't get surprise billing. We're going to set up a process in arbitration. How many people want to arbitrate? Apparently, everyone is the answer. So, we got way, way more of these things than we expected. So, great. As background, Congress passed the law, which became effective in 2022, to help curb so-called surprise medical bills, balance bill received by a patient in situations which they have no control over who's involved in their care, such as, for example, a hospital where you don't know what doctor is operating on you, possibly because you're unconscious at the time, or what anesthesiologist is involved, or whatever. Frequently, patients incur these bills when they obtain emergency care from a facility which itself is out of network, or non-emergency services at in-network facilities, or possibly from the ambulance ride, or possibly a lot of other things. Our system is somewhat fragmented. So yes, you might get a bill from whomever that you didn't expect. And the ambulance might take you to a non-covered facility because again, you might be unconscious at the time. So that could be a problem. In these situations, the law is designed to forbid the out-of-network provider, whether that's the hospital or the doctor's office or the doctor themselves, from balance billing the patient to collect the difference. So we are basically going to force you to be treated like you're in network in this situation. All right. We are now, as a matter of law, declaring that you're in network deal. Well, of course, the you're in network deal, less popular with the insurance companies, as you would expect, because, well, they're not in network for that it's like we suddenly have this bill from this person. We don't know who this is. And like, we have to pretend that they're our client. So they're not so thrilled about that. To protect the patients, the relative law establishes an alternative dispute resolution, allowing the parties to submit claims to an independent dispute resolution panel to determine this. So we could go to court over it, as we always could, of course. We could have a lawsuit over it. But we also established this dispute resolution process as well to do that. So you can go that way. This dispute resolution process was intended to be streamlined and efficient. We're going to get around some of the problems that courts bring to bear. Of course, also courts themselves are a bit overloaded. So we're going to create a different path that will be faster and better and cleaner. But, this has not gone that well because they've been inundated with submissions since the law became effective. So a lot of people think their bills are a problem. The volume of claims has created a backlog hindering providers' ability to obtain reimbursement for services. In an effort to promote transparency, the Department of Health recently issued a status update on the arbitration process. The report revealed several key findings regarding volume, eligibility, and outcomes of claims. So the law's implementation has been a little bit tenuous, which sometimes these laws, when implemented, are a little bit tenuous. What the Congress or the legislature of your state or whomever thinks will happen and what actually happens sometimes have some different results. The report released by the government indicates overall numbers of claims that have been filed. Since the submission portal first went live April 2022, there have been 330,000 claims. This is 14 times more than the initial estimate. So initially we thought maybe 30,000, and what we got was 330,000. So, well, it turns out our alternative path really, really popular. People would like to do the alternative path, but we were expecting like 30,000 and we got 330,000. So we weren't really set up for this. So it somewhat slowed our streamlined, efficient process. Yeah. The report indicates that this streamlined, efficient process has rendered determination in favor of one party or another only in a small fraction of the cases. Approximately 42,000 disputes decided as of March. So we thought maybe we'd do 30,000 a year. That was our estimate. We thought 30,000 claims a year. Hey, we actually did 42,000. So we're doing good. We're almost doing 50% more than we thought we could handle. But unfortunately, the 50% more that we thought that we could handle is somewhat dwarfed by the 14 times number of requests. So 50% versus 1,400%, these two numbers are a bit different. Third, these panels have closed more cases than decided. Overall, more than 100,000 claims, more than 4 times anticipated, have been closed. So we thought maybe, there'd be 25,000 that would just basically be dismissed, as it were, because they were improper claims, but we have 100,000 of them. Some claims, of course, were closed following successful negotiations. Other claims were closed due to failure to pay fees. A large number, 40,000, were closed for eligibility reasons. So sometimes it's because they didn't pay us, sometimes it's because they settled, sometimes it's because they weren't eligible in the first place. So people have seen this as an avenue to get relief who weren't entitled to relief. But, they thought they were. So, yeah. The parties that are challenged, which often are the hospital, of course, have challenged the eligibility of about a third of the claims, which, you would kind of expect, your motion to dismiss, whatever we call it, but this is an arbitration process. We'll call it something different, but it's the same thing. Motion to dismiss, failure to state a claim. You are not an eligible party. A third of the time. Sounds about right, but apparently that was way more than we expected. I'm not sure why, but it is apparently. Non-issuing parties frequently object that claims are not eligible for arbitration, including lack of timely negotiation, arbitration substitution, or because the claims involve insurance programs outside the scope of the relevant law. So I'm not sure why we expected them not to file a motion to dismiss for failure to state a claim a third of the time. I'm not sure why we thought that number wasn't a realistic number, but apparently we didn't think that would be that many. But that's what we got. In addition to objections lodged by, the doctors or the hospitals, the arbitration panel have an independent duty to confirm claims, which, makes sense. Subject matter jurisdiction by another name, right? It's not a court, but it's the same principle, right? Subject matter jurisdiction, can this body hear this thing? These determinations require the body to engage in what can be a complex analysis, because sometimes, of course, it is, frequently requiring the submission of additional information from the parties. The report finds that these eligibility determinations represent a cause of delay. So we spend a lot of time trying to figure out whether or not you're eligible or not. And that consumes us. So, yeah. Finally, in an effort to help resolve the delay, the status update includes the Department of Health has begun requiring the initiating parties to submit additional information. So we are going to try to solve this problem, at least in part, by requiring the people who are submitting the request to submit more stuff as part of their request. So we want to increase the paperwork burden on their request and make it harder to file the request and maybe discourage people that way. So, okay. The department has also modified the arbitration portal to require the input of additional information. These are among the ongoing technical improvements. So part of the way we're solving this is by requiring the people who want our involvement to give us more information and just make it harder and more difficult. So some people, presumably, who are eligible will just simply be frustrated out of it. So we're trying to solve the problem that way. Let's see if that works. Meanwhile, legal challenges to the entire regulatory scheme itself also continue. Because, a lot of people maybe don't think that this is a good thing or even a legal thing. The developments have fueled speculation that Congress might step in and pass additional legislation to fix this problem. So, of course, there have been lawsuits over the entire scheme because, of course, there are. We don't really like the arbitration. We don't think it's set up properly. We don't think it's fair. We think their processes are bad, blah, 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 blah. So there's been lots of problems. So maybe Congress will have to come in and try to fix it. And I'm sure they'll fix it in a way that will create no new problems in its wake. I look forward to this new congressional legislation. Thus, that brings us to the end of the discussion over the moment of this federal law, which tried to stop surprise billing, which is a legitimate concern. No one can deny that. You are brought to an emergency room for some treatment. Do you have control over which doctor helps you? Do you have your control over your anesthesiologist? Do you have control over your surgeon? Do you have control over which doctor comes to visit you during rounds? Do you have control over your nurses? Probably not in a lot of situations. And what are you supposed to do? Like figure it out for each one. And it's like, I can't get this treatment right now. We have to spend 2 hours, going through the finer points of the charge schedule to figure out whether or not you're covered or not as I'm bleeding. So, this is a bit of a problem. Congress tried to solve this problem by saying, okay, fine. In these situations, we'll just basically effectively declare that you are in network. Okay, you're in network now. Everyone's in network. That solves the problem, right? Well, not so much, because it appears that 14 times more people have wanted to take advantage of this because, the hospital bills are very expensive. And somehow they didn't see that coming. So there's been controversy. Also, the entire scheme itself, of course, presents legal problems for obvious reasons, because we are trying to set up something in substitution for courts, which, you can do. But, maybe that wasn't set up properly. Maybe it's not being implemented properly. But no problem. Congress is aware of the problem and is going to fix this right up. So I assume we can look forward to a clarifying law any day now, which will solve this and every other problem in our healthcare industry. And that, for the moment, brings us to the end of discussion of this case. Thank you for being a friend. Push the button. Thank you for being a friend. We're gonna a friend and then a confidant. Ba, 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 ba. Thank you for being a friend. Ba, 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 ba. All right, let's try this case. Man, we got so much good stuff today. I don't think I'll do that story today. And I don't think I'll do this story. And that still leaves us with 5 more stories. All right. We're probably going to go up to 4 stories edited a day at this point pretty soon. We're already doing 3 edited stories a day, 1, 4, and 7, incidentally. We're going to have to go up to 4 edited stories a day. We're just generating way too much content. We're just generating too much content. So we'll have to go to a different release schedule. So I suppose if we released in the morning, that would be a release at 10, but we're streaming at 10. Well, we could do like 12 to 4 and 6, I guess. Or maybe 1, 3, 5, and 7. Do it on 2-hour release schedule. Ugh. I don't have to do all 5, but all 5 are good. They're all good stories. They're all good stories. There's too many good stories on the list today. Well, even on the weekend, because we're generating so much content. Yeah, even on the weekend. So we have enough. Do we have enough content to do 28 stories a week? Yeah, I think we do. So if we do 4 edited stories 7 days a week, that's 28 stories a week. We may have enough content for that. 28 stories a week. I'd be far and away, no competition in my wake. Far and away the most voluminous producer in the law tubes. Far and away the most voluminous producer. Everyone else looks like a lazy bum compared to my output at this point. Holy shit. All right. In loot box news, Nintendo is the latest company to be sued over its loot box mechanics. So, this is something we've definitely seen in a lot of video games. For those of you unfamiliar, in video games, you can often buy these things that are loot boxes, but you don't necessarily know what's in it. You know, sort of the type of thing that's in it, but not the specific thing. And the idea is that you're basically taking a chance on which specific item it is. And maybe it'll be an ultra rare, super cool item that you can't get any other way. So, take your chances on this mechanism. If this sounds suspiciously like gambling, it's suspiciously like gambling, but you can't cash out what you get. So it's distinct from gambling, or so the argument has gone. Anyway, we are suing Nintendo for their particular version of the loot boxing. So let's learn a little bit more about this particular lawsuit and some of the issues involved. Let's get started with this. An under 18 gamer with support from a guardian is suing Nintendo over the company's loot boxes that charge real money for a chance at what they perceive to be at least an advantage. So yeah, sometimes you're buying it for mechanics, sometimes you're buying it for some sort of costume, sometimes you're buying it for a weapon or a shield or some armor or something. But yeah, you're taking a chance that you'll get the really, really cool items. Anyone can win. Maybe it can be you. The class action lawsuit was originally filed last month, but has now been moved to the federal system. So they have removed it, as we call. The lawsuit claims that Nintendo in particular engaged in deceptive and illegal practices through the transaction it sold to players of its mobile game, Mario Kart Tour. So Nintendo has somewhat, and not enough in my mind, got involved in the mobile market. I think Nintendo is squandering a bit of an opportunity in the mobile market. I think they could absolutely crush and dominate all mobile gaming. But for some reason, they've been a little bit resistant to this. They've only very tentatively dipped their toes in the water when they could absolutely crush everyone before their wake. But they're not doing that. But they have released the Mario Kart Tour. What they've done apparently is entice players to pay actual money for a chance-based game that is absolutely not gambling, even though it's chance-based. And the plaintiffs have alleged the company did something immoral, unethical, oppressive, unscrupulous, and or substantially injurious to the consumers. They've also specifically alleged that this is all in violation of Washington State Consumer Protection Act, which every state has some version of, because, consumers, we want to protect the consumers when it comes to business practices. That sounds like a good thing, and we think this violates that law. For years, the Mario Kart Tour has been a freemium offering that's been popular, employed a, let's say, luck-based system that would entice users to roll dice, and depending on which way the dice comes up, you might win one prize, or you might win a different prize. And sometimes the prizes are really, really nice. And that's not gambling, though. Pulling on the spotlight pipe, which is in no way like pulling the arm of a slot machine, would release gliders, carts, or characters at random that could potentially improve performance in the game. Each pull of this, not in any way a slot machine, not in any way the arm of a slot machine, would cost about $3. The resulting loot box could feature prizes, but has been somewhat derided as predatory because you're putting real money into the device where you pull the pipe that, depending on the roll of the dice, gets you some prize. Sometimes it's really valuable. Won't you just take a chance on this totally not a slot machine gambling device? Nintendo discontinued the pipe pulling slot mechanism in 2022, replacing it with a more straightforward in-game store. So they got away from the not at all a slot machine with a not at all arm on a slot machine and said, what if we just have a normal in-game store where like people can buy things? And other companies have also done this as well, because, you know, there's been a few of these lawsuits against a few of these companies for the somewhat looks kind of like gambling, but, you know, it's totally okay, even though it primarily affects the children, incidentally. So unregulated gambling with children being the primary players, you know, raises a few question marks in one's mind. But before the not at all a slot machine thing was cut off, the lawsuit states that the plaintiffs, again, who are children, charged $170 on their dad's credit card without permission for the loot boxes. Yeah. Of course, there are well-documented cases that rake up significantly higher bills into the thousands and occasionally tens of thousands of dollars because, you know, it's not like there's any sort of data or information that some people are particularly attracted to gambling-based devices, and some people put money in a slot machine in a way that suggests a complete lack of self-control, and that some people are really have, we might even call it an addiction, problems related to gambling. And that's not all no problem in any way, even though it involves the children who, of course, are particularly susceptible to influence and have less reasoning capability than an adult. So, but it's we don't have any information that's anything like that. Nintendo apparently yielded $300 million in 3 years through this not gambling scheme. So the not gambling scheme was pretty good for the house. $100 million each year for 3 years for the totally not gambling with the children. I'm seeing some potential problems and potential notes of concern. I have notes. I have some notes. Plaintiffs, of course, almost never received the super valuable item that they totally could win, but they almost never did because, unsurprisingly, the slot machine doesn't pay a jackpot every single time. But it's not a slot machine, guys. And would not have made the amount of in-game purchases had they known the true odds, and they would not be given a refund. So, you know, every slot machine probably should post the odds, but it's not a slot machine, so we don't need to tell you. Also, it's not addictive in any way, and it's okay. Nothing to look at here. This, of course, is not the first lawsuit relating to this. Google, Apple, Valve, and basically everyone else on the face of the earth has been sued for this gambling, which is totally not gambling. In each of these cases, the tech companies have come out on top. One lawsuit against EA claimed the loot boxes amount of gambling was tossed out by a Canadian judge. But, you know, there have been a lot of problems and a lot of concerns, and legislation has been written, and, you know, yeah. So, yeah, in many of the cases, they came out on very technical wins, but, you know, still raises some problems. These companies have also faced scrutiny worldwide because, unsurprisingly, gambling is not just regulated by US law. And every other country on the face of the earth would probably like to have a question with you when it comes to the not at all gambling involving the children. So, you know, yeah. In one notable fight against this Epic Games was forced to pay hundreds of millions of dollars in fines for this. So, you know, it's been a problem. Yeah, let's wrap this up. Thus, that brings us to the end of the latest of a saga of cases involving video game companies with the loot boxes, which is not at all gambling, even though it's totally gambling in every possible way. And they've also been sued over this every time for many, many years. Nintendo, like many companies, has abandoned the practice because, you know, it faced a lot of scrutiny and a lot of concern. And also other regulators in other countries have taken a look at it, and it's been a problem. So, yeah, but they're still being sued over the time when they did this, you know, and exploited the children. So how will this particular lawsuit go? Who knows? But it's the latest in a series of things. So It's going super well. And that brings us to the end of the discussion of this story. What should we do? What should we do? I think we should push the button. Yeah. Push the button, baby. Push the button. All right. Turn around. Every now and again I get a little bit longer. Get when in a minute, turn around. Every now and again I get a little bit there. With every little look in my eyes, turn around, bright eyes. Every now and again I fall apart, and I need you more tonight, and I need you more than ever. The night, total eclipse of the heart. He said to walk like a man, talk like a man, walk like a man, my son. No woman's worth crawling on the earth, so walk like a man, my son. Ooh, walk, 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 walk. I love you all. My love is like a shadow on you. Okay. I hope that's a good thing. A federal judge has thrown out a lawsuit as it relates to rent control measures in the city of St. Paul. So, several places in the United States put in place a rent control measure on how much a business is allowed to increase rent on property. So, typically, these laws will, to the extent they exist, which they don't necessarily exist everywhere, but to the extent they do, they might forbid a place from raising rent at more than a set percentage. So the most you can raise the rent is some percent that's fixed by law. Of course, in some places, the rent is fixed at a permanent price. Like in New York, for example, where they're basically fixed. And if you get one of those rent control apartments, it's really, really nice because the price is way cheap compared to what it should be. So the city of St. Paul has put in place measures that are like this. And there was a lawsuit claiming that this was illegal, but a federal judge has thrown out the lawsuit. So let's learn a little bit more about what is going on in St. Paul. The federal judge threw out the lawsuit against the city of St. Paul, followed by the apartment owners who claimed that the rent control measure was akin to taking property. So you have taken our property, but probably no in the relevant law, right? So this is just a mere regulation dealing with property, not taking a property. So the typical way that this is done, but of course not exclusively. But one of the hallmarks you use when you're thinking about a regulation that impacts property is whether it deprives the property of all reasonable lawful use. So as long as it doesn't deprive the property owner of continuing to do the thing that they would normally do with the property, it's fine. So for example, yes, we can, mandate that you install like phone lines or cable or, electricity or stuff because it won't prohibit you from doing, the thing you would do on your land. You just have to do it this way, right? So one of the standards we look to is whether or not the regulation deprives you of all reasonable commercial use, which of course would depend on the nature of the property in question. So this rent control probably does not rise to that level. And that's where the idea. The U.S. District Judge filed the judgment that closed the lawsuit. They denied the plaintiff's request for summary judgment or a final ruling without trial, which of course granted by requesting judgment for the city because it's a straight issue of law, right? No one really disagrees on the facts here. or they don't disagree on the facts of the way this matters. So there's nothing for a jury to do, right? It's just a straight question of law. Given these facts, who wins? St. Paul approved the city's rent control ordinance in November 2021 by a voter referendum. The 3% cap on annual increases, considered at the time one of the strictest rent controls in the nation, was amended last September, exempting affordable housing as well as new construction for 20 years. So you don't have you can have uncapped if it's new construction. It can be uncapped for affordable housing because that's already regulated in a different way for affordable housing. But otherwise, for existing properties, no more than 3% a year, which is, basically inflation. I mean, on a historic trend, inflation rates at the moment, maybe not 3%, but in a historic way, 3% is just basically above the inflation rate. So keeping it basically to the price, which also incidentally does nothing to deal with differences of demand, right? So yeah, it might be reasonable to cap it out at that if there's no change in demand, but of course there's a change in demand. And so you're fixing the price, lower supply. But that's what St. Paul wanted to do. The relevant company that sued owes an apartment building, and they're not happy about this because they'd like to have rates that can fluctuate more wildly. The judge's opinion found little substance in the claims, which argued that the 3% voter-approved initiative could reduce property value and lead to less investment, which maybe it will, but that's not necessarily enough in and of itself. The plaintiffs contending the amended ordinance will not work and not meet its objectives may be true, but poor policy is not a due process violation. So again, what they are trying to do and what will happen, are possibly disparate. But just because what will happen is not what you expected to happen is not what makes the law illegal. So are they correct that these laws will be ultimately counterproductive and not accomplish the objective? Maybe. And if they are, maybe they will need to amend the law. But, just because it will wind up being a bad choice doesn't preclude you from making a choice. You are free to make bad choices. And my prediction that this is a bad choice for you does not deprive you of your freedom, including if you're a city. So the mere fact it won't work out, even if true, not enough. The judge pointed out the city had crafted a way to seek rent increases of up to 8%. So they even have a way to get past this limit through a process. The judge noted that unlike a 1976 case in Berkeley, St. Paul had granted most of the exemptions without even a public hearing. The volume of appeals has also been low. Out of 152 applications, there are only 5 appeals. So in other places that had a process to allow for exemptions, they didn't really allow them. But in this case, they do. So they allow them much more freely. So there is more process available to get redress if for whatever reason you need it. So if you have an as applied reason, you can go up to 8% and they grant them much more freely. So you don't even have an as applied challenge going on. So they thought to solve that problem. As for allegations that violates the contracts clause of the Constitution, the judge noting the contracts clause, I'm sure, is dead, but also noting it is moot, given that the apartment building has been exempt from rent control. So does this violate the contracts clause? No, because you're not bound by the law in the first place. Also, the contracts clause is dead. Justice Thomas would like to revive it, but it's dead. So, no. The judge was also not swayed by arguments that limiting landlord rents amounts to government taking money away from them in 2 different ways, in both cash on hand and resale value of the property. No, sorry. Like all regulations, they might impact the value of the land because the regulations might make the property more or less attractive, right? The city could pass regulations in a way that makes the land more attractive. I'm assuming you'd be really happy about that, but they can also pass regulations in a way that makes the property less attractive. But again, unless it's a complete taking, and by complete taking, we mean deprives of all lawful legal use. So unless they're condemning part of the property or depriving you of all property use, the fact that they change the regulations in a way that makes the property less attractive, well, that is not a taking. Sorry and all, but the city gets to pass its regulations. So yeah, that's just the way it goes. Pointing to precedent for rent control across the nation, the judge noted that the housing market is highly regulated and courts have long held Comparable regulations policies are constitutional because they are. Because again, it's not a complete taking. It's not a complete deprivation of property. So as long as it's reasonable and they allow for exemptions for the as applied and they actually grant the exemptions, sounds like we're on pretty good legal footing to me. The judge adding, quoting relevant case law, that in rent control contexts, the Supreme Court has consistently held states have broad power to regulate housing conditions and the landlord-tenant relationship without paying compensation for economic injuries that such regulations entertains. Yeah, pretty much. Again, this is just what we call a regulatory taking. All right? This is just a regulatory taking. You can pass the regulations. It's fine, as long as it doesn't deprive of all lawful or all reasonable commercial use. So as long as you can continue doing your thing, you're fine. You want to rent property. You want to build an apartment complex on the property that people will be able to rent. Can you still build the apartment complex and people can rent from them? Yes, you can. You can still do that. So you've not been deprived of all reasonable commercial use. The fact that it's slightly less attractive, well, that doesn't count. So go away. Thus, that brings us to the end of this case against St. Paul, where St. Paul, by a voter initiative, put in place a 3% rent hike cap for existing properties, but also allowed for properties to go up to 8% if they can show a need, and basically grants them almost pro forma. So it's not really a problem. And they do this. Now, the apartment complexes would probably like to go beyond 8%. They'd like to increase the rent even more than that. They'd like to be able to charge whatever rent strikes their fancy. But the court looking at this be like, well, I'm glad you want those things. Those sound like good things to want, but the city of St. Paul says no. And the city of St. Paul can make that choice. This is a regulatory taking. You're still allowed to have the apartment complex. You're still allowed to have people rent from them. So you still can do with your land the same thing you could before. So everything's fine. But it's less attractive for me. Well, I'm sorry about that, but that doesn't count. And the case law is clear on this point. So the judge throwing it out is completely not a surprise in this light. And that brings us to the end of discussion of this case. Is Artie here? Hello. What is pro forma? By form means automatic. By rote. Pro forma just means automatically. Standard. Rote. Customary. That kind of thing. It's really infectious how much you love what you're doing. Thank you. I really do love what I'm doing. I love this shit. I love this shit very, very much. I love this shit very, very much. I love that it lets me learn new law. I love that I get to talk about law. I love that I get to explain the principles. I love that I get to teach. It kicks ass. Look at me. Look at me. I'm a happy uncivil law, man. Look at how happy I am. I'm a happy uncivil law. This is great. I love my life. This is great shit. Mr. Sun came up and he smiled at me. Said it's gonna be a good one, just wait and see. Jumped out of bed and I ran outside, feeling so is stressified. It's the best day ever, best day ever, best day ever, best day ever. All right, outstanding. Have I seen Studio C skits? Yes, I've seen some of the Studio C skits. They're cool. Yeah. This is what I like. Yeah, this is true. My singing is so bad it won't get content ID'd. I like to think that my singing is so bad it can't even be identified as the original work, and so isn't even copyright infringement. I have so mutilated the original work it can't even be identified anymore. So it's a fair use. It's transformative. It's really transformative. Oh my God. Did I push the button? If not, I'll push it again. It doesn't matter. All right. In drag show news, Florida is facing this issue as there's been a lawsuit filed by a restaurant that would like to do the drag shows. So there's been an issue on the drag shows as it relates to kids, as it relates to generally, and we get into these conflicts as it relates to the First Amendment. Now, what is notable, of course, is as it relates to prurient kinds of performances, one that involves an appeal to our baser instincts. The state has long had the ability to regulate shops and places that appeal to these instincts, particularly as they appeal to them in greater and more overt ways. So, particular kinds of businesses that appeal to these base desires can be regulated as to who can come into them, where they can be, what hours they can operate, and so forth and so on. So, we get into this sort of question as it relates to a drag show. What sort of part of the continuum are we on that issue? As it relates to this, can we ban them outright? Can we regulate where they're occurred in parts of town? Can we regulate their times? Can we regulate the ages of the people? We get into these kinds of questions as it relates to these more base instinct, potentially appealing entertainment shows. So how does that relate to this Florida law? Let's get started with this. A popular Orlando restaurant that features drag shows filed a lawsuit against Florida less than a week after Florida signed a bill that targets the drag performances. So, bringing that conflict right to a head. Florida passes law that deals with the drag performances. Is this lawful? Could be, maybe, depends on the details. We'll see. The lawsuit filed in Orlando court by the owners of Hamburger Mary's claims the state is depriving its First Amendment right of free expression, which, is obviously the issue at hand. And our ability to regulate that expression, of course, depends on the details. Time, place, manner, for example, is it? And as it appeals to things that might reach towards and potentially actually meet the potentially obscene, the state's ability to regulate that within a First Amendment context becomes more and more justified. So that is sort of the issue that's in play. DeSantis made the legislation a part of his agenda. He signed the bill restricting the drag performances, along with bills that ban gender-affirming care, which gets into the ability of states to regulate medicine, in which they have broad authority in general, of course. Restrict discussions of personal pronouns in schools, which to the extent we are doing that to our teachers is probably lawful because they are state employees and we're regulating ourselves. And force people to use certain bathrooms, which again raises a bunch of legal issues. So there are a whole bunch of issues here that they are doing. Some of this may be lawful, some of it may not be lawful. It depends on the details. It depends on how expansive what they're doing is. It depends who the law applies to. If it applies to the government or governmental employees, probably lawful. If it applies to private citizens, more concerning. As it relates to charged speech that relates to baser instincts, The more that it appeals to that, the more it can be regulated. So, like many things, it depends on the details. Hamburger Mary's Bar and Grill has a dozen locations in the United States. According to the lawsuit, they hosted a family-friendly drag show. And incidentally, and not for nothing, I have seen, as I'm sure many of you have seen, some TikToks from shows that were advertised as family-friendly. And in many cases, I would have to respectfully dispute the label, assuming that there is such a thing as a family-friendly drag show, assuming that exists in principle. Many of the shows I have seen have been somewhat provocative and question that label. So, yeah, this Florida law would force them to ban children from the showings, which, again, possibly is legal. Because, again, we're thinking about this as it might apply to other charged performances in other kinds of industries and shops and bars and clubs that appeal to those kinds of things. So, can we ban the under 18-year-olds? Sure, we can. We do it all the time. Can we ban the children from these kinds of shows? Maybe. Maybe we can. Maybe that's the same thing. Is that the same thing? Is it a different thing? How family friendly are these shows? The First Amendment details are questionable. Proponents of the legislation say the law is meant to keep children from viewing the explicit performances, which, we do as a matter of law in other domains. So there's that. Lawyers for the business argue the law is so broad, it could apply to almost any performance that involves a man dressing up like a woman, even if the performance isn't base in its nature. So maybe, but then again, maybe that's an as-applied challenge on the details as opposed to a facial challenge. So maybe. The lawsuit says business owners can't risk having their licenses suspended or risk the criminal prosecution for, the treatment of minors, which, is often a problem when you have dereliction of a minor and promoting the dereliction of a minor. Yeah, that raises a problem. So they'd like to have the drag shows, and they're not allowed to have the drag shows, and they're not allowed to have men dress up like women, even if they're not appealing to base instincts. So, okay. The governor's office didn't immediately respond to the message seeking comment for the lawsuit, but it's all very complicated. Not all drag performances or performances are sexually explicit. Yeah. Thus, that brings us to the end of the coverage of this place that serves hamburgers, which also wants to do drag shows. I'm not quite sure how hamburgers and drag shows necessarily go to each other, but that's what they'd like to do. The state of Florida says not so much as it relates to the children, and they have filed a lawsuit claiming First Amendment protection. So this is going to depend a lot on the details, of course. It will depend on the nature of the law and how it's written as we're thinking about a facial challenge, and also thinking about exactly what this restaurant wants to do as we're thinking about a facial challenge. But of course, as we appeal more and more to the baser instincts of humanity, we know that we can regulate that because we do that for certain clubs and certain stores that specialize in that domain, where we can regulate where their businesses are located. We can regulate who they let in the door. We can regulate how they're conducted, and so forth and so on. So where on the continuum are we as it relates to this is not immediately clear. But Florida is trying to do this. We'll see how it all pans out. And that, for the moment, brings us to the end of discussion of this case. Elizabethan Shakespeare could be qualified as drag. Yeah, fair enough. Fair enough. I don't know what they did in terms of costuming back then, but fair. Could be. Yeah. Yeah, Dolly Parton lost a drag show for a lookalike contest. Yeah, that also happened to who did that happen to? Was it the silent movie star with the mustache? The kind of Hitler mustache? Uh, where he went to a lookalike contest and also lost? Yeah, that happened. That's happened a couple times where like the guy themselves shows up and loses their own lookalike contest. Chaplin? Yeah, I think it was Chaplin. Yeah, yeah. So I think that happened to Charlie Chaplin too. Injunction granted for pistol brace cases for the plaintiff only. Okay, that's interesting. All right. In transgender news, the great state of Montana has passed a law that defines sex as binary. So, whatever might be true of gender, we are trying to say that binary is male and female, and that's all. So, we signed this into law. So, we are continuing this issue on the issue of gender and issue of sex, and we've solved this law by saying it's male and female, and that's it, which I'm sure will solve the issue right up. Let's read more about this story. The governor's office announced Saturday that the governor signed into law a bill that inserts binary reproductive language of male female as it relates to sex in dozens of parts of the state code. The final version of the law, although heavily debated as one would do in the legislative session, distinguishes male and female by the presence of XY or XX and the production of sperm and cells under normal development. So, not clear if the law contemplates things other than XX or XY, but it says that it's XX and XY, which, leaves some people a little bit out in the cold because there is occasionally things other than XX or XY. So, not sure if we're dealing with that issue or not. So, okay. And human beings are exactly two sexes, male and female, with two corresponding types of gametes. The sexes are determined by biological and genetic indication of male or female, including sex chromosomes, naturally occurring sex chromosomes, gonads, and non-ambiguous internal and external genealogy present at birth, which again, in some cases, is not as non-ambiguous as it might be. I mean, it's relatively rare. It's very rare, but it does occasionally happen. So, how are you dealing with this for the non-XX and non-XY? Where are they in this equation? I don't know. An amendment added to the bill late in the session states the definitions include people who would otherwise fall within the definition, but for a biological or a genetic condition. I don't know what that means. I don't even know what that means. So, like, we are defining it as being that, even though if you have a genetic condition. So, does that mean that XXY would otherwise fall into XY? Is that what that means? Is XXY otherwise fall into XY or otherwise fall into XX? I don't 100% know. So that phrasing leaves a little bit something to be desired, to be honest. Probably a better way to go about this if you want to go down this road is simply say XY and everything else, which is perhaps not ideal, but at least includes every possible category. So you're shoving everyone who's not XY into female, which, may lead to its own problems, but at least you've defined the entire class of possibilities. So that's nice. But here we're leaving it more ambiguous, which seems problematic. The bill, which was drafted in part by the Montana Family Foundation, passed through the legislation earlier this year among party lines, as one would expect. The bill's sponsor framed it as a policy responding to the transgender issues, saying it will help to ensure Montana law residents are based on biological birth. So the Montana legislature are trying to deal with some of this issue as a matter of state law, but not clear how well it deals with it. Thus, that brings us to the end of the case for the moment of the Montana legislature, which has attempted to deal with the transgender issue by saying there's male and female based on XX and XY, and everyone else who would be XXXY, but for their condition are assigned to their respective category, which I'm not 100% sure what that means. But they're trying to deal with this issue. So I'm sure this will be challenged in many, many ways. But looking at this issue as we try to figure out some of these issues, and that for the moment brings an end to discussion of this story. Push the button. Yeah. Yeah. Okay, I just read that bill, so I don't really do that. Okay, we got Florida Man. We have reached our end, and we've reached Florida Man. There is a rise in people identifying as trans. That's not debatable. There is a rise in people identifying as trans. A sharp rise. All right, Florida Man. In today's Florida Man story, we turn our attention to a St. Petersburg man who wanted to have a turtle friend, which is understandable. Turtles are cool. You would like to have a turtle friend. I might like to have a turtle friend. Sounds like fun. Unfortunately, we acquired our turtles by stealing them. And we also stole some rare books along the way. So, not great way of acquiring the turtles by the theft. So please don't do that. Let's learn more about Turtle Thief. Two endangered Galapagos tortoises, some rare books and comic books, went missing from various locations around Florida. So we are stealing, maybe the tortoises like comics? I don't know. Are tortoises known for their love of comics? Is there a tortoise-turtle divide when it comes to Marvel versus DC? Are tortoises more Marvel and turtles more DC? Is that why they're different? Is that why they can't get along? I have questions. On Tuesday, a couple was arrested after police determined that the items on eBay were the stolen items. So the police, not being stupid, looked to things like Craigslist and eBay and pawn shops and stuff to see if the stolen items turn up. We can't help noticing that these items turned up on the eBays that you were selling. Kind of gives us a clue. And we found that you had some other things at your house, including the reptiles. So, okay. Joshua McCarty Thomas, who is 46, was taken into custody after detectives searched a search warrant at his home, discovered one of the missing tortoises dead in a freezer, but another alive at the yard. So unclear why the tortoise was dead in the freezer. Was he planning on eating it? Was he preserving it? Did it die of natural causes and he just couldn't bring himself to get rid of tortoise friend? Was he keeping it in his freezer as a way to keep that last bit of bond with his loved tortoise? Or was it for tortoise soup? Was it for tortoise soup? Is soup time glorious time for you and me when it comes to the tortoises? I need to know. According to the State of Florida database, the Shashi McCarty Thomas is employed by the Department of Corrections as a correctional officer. So, we are spending our time around criminals, and maybe we met a fence during our time as the Department of Corrections officials. We learned about fences, and we think that this fence has taught us about the magic of fencing the comic books, the rare books, and the tortoises. These are the things we're fencing, maybe. Maybe that's what we're doing. We learned the criminal trade from the best, but now we will unfortunately join them behind bars. Exciting. Apparently, this person was dismissed during their time as a trainee. So they didn't make it very far in the Department of Corrections, maybe because they let it slip that they're really here just for the tortoises? Unclear. The juvenile tortoises had microchip implants. So Fish and Wildlife over here scanned the chips and said, we can't help noticing that these tortoises were registered at St. Augustine Alligator Farm Zoological Park. So the tortoises have been tagged. They've got LoJacks. And we've checked the tag, and we can't help noticing they were registered at a zoo. You're not supposed to steal the tortoises from the zoo. Also, just purely practically, how did you steal the tortoises from the zoo? Seriously, I want to know. Did you do it daylight hours and somehow keep the tortoises under your arm and no one noticed? Did you have a backpack? Did you sneak in after hours and break into the tortoise cage? How did you do this? I need to know. How do you jack a tortoise from a zoo? I have questions. Each of the tortoises is worth about $10,000. So some grand theft charges coming down your way. Fun and exciting. In a Facebook post announcing the theft, the zoo said the tortoises had been there since 2017 as part of a captive breeding program. The rare reptiles required a special diet and supplements. Not clear if tortoise thief was also giving the diet and supplements. Maybe that's why the tortoise died and was in the freezer. Didn't get his supplements. Didn't get his protein powder. You know, I really understand that is a bummer. The tortoises can weigh up to 600 pounds and can live for 150 years. They are a long-living friend. St. Petersburg police say that the people involved also face commercial burglary charges in connection to rare book theft committed at two businesses, Howsom's Bookstore and Lighthouse Books. In each of the cases, the books said to be stolen were worth thousands of dollars. So maybe we are a very high-end thief for offense, trying to supply some very eccentric clientele. We're doing an Ocean's 11 over here, and what they really want is the tortoises. Okay. An arrest affidavit for Joshua also listed Dashi, the former corrections official, as co-defendants, stating that the Boston American newspaper collection was among the stolen items. The MO of the burglary matches that of other burglaries, including that of a potential lockpick. Unclear if lockpicking lawyer is involved in this story. Lockpicking lawyer may be involved, unclear. The collection was sold on May 7th on an eBay account that was called You Can Never Have Too Much Awesome. Wow. That's a great eBay account name. I never got that clever. You can never have too much awesome. Well, it turns out you can have too much awesome, particularly if the awesome was acquired through less than legal means. So, yeah. Wow. Pictured here are a forensic technician with the St. Petersburg Police Department, which is carrying the body of the tortoise in a brown paper bag. Wow. That's a hell of an image. The forensic technician is carrying the tortoise in a brown bag away from the home. Wow. I'm going to redo that and redo it as an outro. That's good shit. Thus, that brings us to the end of the case of the stolen tortoise, which is actually pictured here in this photograph, as the forensic technician with the police department removes the dead tortoise from the home in a brown paper bag, presumably to protect the tortoise's dignity and not let its body be exposed to all the cameras. This is so great. We got the forensic technician over here removing tortoise body. Unclear if there will be an autopsy performed on the tortoise to figure out a cause of death. Unclear if the tortoise was killed through illicit means. Was the tortoise given a good life? Did it die happy? Was it happy in its new home? Who wanted the tortoises and why? Why are we getting these things? So many questions left unsolved in this Florida man mystery. And that, for the moment, brings us to the end of discussion of that case. Well, my friends, we have reached the end of the story, the end of the stream. We got a lot of good stories today. We got so many good stories today. Too many good stories. We have too many good stories. How are we going to get all these stories out? There's just too much good shit happening. Too much shit happening. How do we release it all? I don't know. Like, do we go to 4 stories a day? Do we go to 5 stories a day? What the hell are we doing over here on Uncivil Law? Holy shit. We are producing so much content. God damn it. Yeah. We are producing more content. At this point, we might be producing more content than all of LawTube combined. I don't know that for sure, but we're probably close. Wow. Wow. Yeah. Yeah. So we are definitely setting the trend over here. So I don't know what we'll do going forward in terms of that. Well, I've got editing to do and stuff. So I've got to do well, first I should probably go to the gym. Because if I don't, I probably won't do it. So first thing I have to do is I have to go to the gym. Then I have to, well, yes, I have enough time. Then I have to, because I have the stories posted for 1. I just need the story posted for 4. So I have enough time to do that. So I need to go to the gym. Then I need to come back and I need to post the stories for 4 and 7. Then I need to edit the content for today. And then maybe I can do Zelda. So I need to do those things. And we'll see how it goes. And go from there. Oh, Beaufort, South Carolina. I used to live in Beaufort for a little while. My family did. It's a nice part of the state. Beaufort is cool. I actually like the way that low country smell is. I like it down there. It's cool. All right. Anyways, I'm going to sign off for now. This has been fun. I will see you guys around. If not before then, I'll see you tomorrow. So until then, my friends, I hope all is well. Cheers, my friends, and goodbye.